afternoon, everyone. I'd like to welcome our new Manhattan District Attorney, Alvin Bragg, and thank him for joining us today and participating in this important conversation about how to keep people with mental illness and their communities safe and healthy. DA Bragg is just starting his second month as Manhattan District Attorney, and we are grateful that he is taking the time to speak to all of us about how his office can better address people with mental illness, particularly those with serious mental illness that are too often failed by both the healthcare system and the criminal justice systems. These failures can have tragic consequences for individuals with mental illness, their families, and their communities. Here in New York City, we've witnessed the tragedies that can result when people with mental illness do not receive the services that they need. People suffering with mental illness like Saheed Vassell and Kawasaki Trawick have been killed in encounters with the police. New Yorkers are going about their daily lives, have been injured or killed by people with untreated mental illness, as was the case with Michelle Go, who was recently pushed onto train tracks by a man with schizophrenia. Just recently, one of John Jay's own graduates, Detective Wilbert Mora, was killed responding to a domestic dispute by a man who reportedly was suffering from mental health issues. Our John Jay community has been mourning Detective Mora's death, and I'm proud that our students have been honoring Detective Mora's legacy by writing thousands of condolences cards to his families in recent weeks. But these are extreme examples. We know that most people with mental illness are not violent and don't commit violent acts. That said, we still must do more to prevent these deaths. We must also address the broken systems that too often punish instead of treat people with mental illness. It's estimated that more than half of the people on Rikers Island have mental health needs, and people with serious mental illness make up an increasing proportion of those in our jails. In fact, this was one of the points of consensus that emerged when John Jay collaborated with the National Organization of Black Law Enforcement Executives to bring together law enforcement, elected officials, community leaders across the country in a series of convenings called the Future of Public Safety Series. These leaders agreed that we need to invest in treatment and services for people with mental illness and address commonly co-occurring issues of substance misuse and homelessness. We know that district attorneys have an important role to play in identifying people with mental illness and, when appropriate, connecting them to treatment and services that will make everyone safer in the long run. That is why we're grateful that the Greenburger Center has partnered with us for this webinar series that shines a light on the role that district attorneys play in addressing mental health issues. Before we begin this conversation, let me introduce DA Bragg. DA Bragg became the Manhattan District Attorney on January 1 of this year and is only the fourth person elected to this office in 80 years. Before becoming the Manhattan District Attorney, Mr. Bragg served as the Chief Deputy Attorney General in New York State, where he oversaw some of the office's biggest cases. He won significant settlement agreements in a variety of matters, from discriminatory redlining to tenant harassment to discrimination against people with criminal history records to unlawful business practices. He served as the first chief of a special unit that investigated police-involved killings. He also led an investigation into the NYPD's stop and frisk practices. Prior to the Attorney General's office, DA Bragg served as an assistant U.S. attorney for the Southern District of New York, where he successfully prosecuted a variety of cases, including those involving corrupt politicians and money laundering for an international drug cartel. DA Bragg earned his bachelor's and Juris Doctorate from Harvard Law School, and he was a visiting professor of law and co-director of the Racial Justice Project at the New York Law School. He is a former member of the board of directors of the New York Urban League and a Sunday school teacher at Abyssinian Baptist Church. DA Bragg grew up in central Harlem, where he is now raising his family. He has spoken extensively and publicly about his personal experiences with crime and law enforcement in his community, and combined with his extensive professional enforcement experience, these things have prepared him for the current role he has as the Manhattan District Attorney. So we look forward to hearing from him. His conversation will be moderated again by Greenburger Center's Executive Director, Cheryl Roberts. Cheryl, I'm turning the conversation over to you now. Thank you.
Thank you, Carol, President Mason, and good afternoon, DA Bragg. Thank you for being here. We are looking forward to this conversation and learning more about your office's plans and policies related to the decriminalization and treatment of people living with mental illness. This is the 6th conversation we have had with New York City's DAs, and we are pleased and honored to be partnering with John Jay College of Criminal Justice. I want to give a special thank you to President Carol Mason for agreeing to partner with us and for those introductory remarks. And to my partner in this effort, Erica Bond, who is Interim Vice President of Justice Initiatives at John Jay, thank you very much. In March, we will have our final program in this series, and we will feature representatives of New York City's defender organizations. Details will be sent out to our mailing list shortly, so stay tuned for that. So DA Bragg, there's so much to talk about today. I want to jump right in and start by talking about one of the most difficult intersections of the criminal justice system and mental health systems. That is when someone with serious mental illness is in the midst of a psychotic episode and interacts with the police. I'm going to apologize to the audience right up front for the long run up to this first question. I typically try and avoid long questions because I know people are here to hear from you, DA Bragg, not me, but there has been so much, as President Mason mentioned, attention and pain associated with this exact situation of late that I think we need to speak about it and to discuss a few facts before we get to the questions. So first, let me start by saying a word about psychosis. Not everyone in mental health crisis also has psychosis. But when a person does have a psychotic episode, that person's thoughts and perceptions will be disturbed, and the individual may have difficulty understanding what is real and what is not. Symptoms of psychosis can include delusions, which are false beliefs, and hallucinations, which are when a person sees or hears things that others do not see or hear. Other symptoms can include incoherent or nonsense speech and behavior that is inappropriate for the situation. At least in part, that may be what happened when NYPD Detective Rivera and Officer Mora encountered LaShawn McNeil. Tragically, as President Mason said, Detective Rivera and Officer Mora were murdered by LaShawn McNeil, who, according to his mother, lived with serious mental illness and believed he was God at times. LaShawn McNeil also lost his life in the encounter. While many see these tragic deaths as related to gun violence, and certainly they are, it seems to me they may also be another example of how police are routinely called upon to deal with people in mental health crisis, which ends in tragedy because, simply put, our mental health system has failed us for nearly 50 years. DA, you recently said that you intend to prosecute anyone who harms a police officer. I think the hope and expectation is, of course, that the threat of prosecution alone will deter someone from harming a police officer. But if someone like apparently LaShawn McNeil literally thinks they are God, then it's unlikely that they will be deterred by the threat of prosecution or even death. Having said that, as President Mason alluded to, it must be said often and repeatedly that most individuals with serious mental illness are not dangerous. Being a young male and having a substance use disorder are actually greater risk factors for violent behavior than living with a mental illness. Individuals with serious mental illness are victimized by violent acts far more than they commit violent acts. And when people with serious mental illness are in treatment, there is no evidence that they are any more dangerous than individuals in the general population. And finally, people with serious mental illness are typically not responsible for incidents of mass violence. So while all those statements are true, it is also true that a small number of individuals with serious mental illness are somewhat more likely than members of the general public to commit acts of violence. And though, unless you are a family member, there is little chance that you or someone you love will be harmed by a person in mental health crisis, if that person harmed or murdered is your spouse, as it may have been for Dominic Rivera, or your daughter, as it was for Michelle Go's parents. The harm and loss will cause unimaginable pain and change a survivor's life forever. We have put a reference in the chat box to a 2021 APA article that discusses the latest about what we seem to know and don't know about the link between serious mental illness and violence. It's more complicated than we had understood to date, as factors may also come into play in addition to psychosis, like whether a person with serious mental illness has a substance use disorder, a personality disorder, or has an adverse childhood experience, among other factors. Nevertheless, it seems to me we might save more lives if we targeted for diversion and longer-term residential intensive treatment this segment of the population with serious mental illness who may also have these risk factors associated with violence. Realistically, that might also mean that some people with lesser forms of mental disease might need to be redirected more quickly out of the criminal justice system and into community treatment, so more attention can be paid to those with serious mental illness. I would suggest that this is not being soft on crime, it's being proactive, smart, and safe on crime, because incarceration of this population does not seem to make anyone better, but only worse. So, DA Bragg, can you talk about whether your office plans to focus on this group of people? And if so, what are the ways you are planning to address their needs and keep the community safe, including police officers, while also providing an opportunity for treatment instead of punishment for those whose disease is at the root of their criminal behavior?
Thank you so much for the invitation and the great work that the Greenburger Center is doing, and in particular for the question you prefaced for the audience that it be long. I really appreciate the depth and the context. I think it's great table setting. I think we're not talking about the facts and research enough. When I say we, I mean the public. I also want to thank President Mason and John Jay. I think it's just great, these two great institutions together hosting this series, and humbled to be a part of it. I'll obviously talk generally. Several of the tragedies you mentioned, we're in Manhattan, and so my office has been involved and will continue to be involved in the matters that are ongoing. So I'll be careful to respond in generality, but do not want that generality to cloud out the fact that those are true significant tragedies that are happening in our city and on the island of Manhattan, something that we're thinking about every day, from the deaths of the detectives to the others that you mentioned. It's something that is top of mind. When President Mason introduced me, and I wasn't planning to talk about this part of the resolution, we'll talk more about the Manhattan DA's office, but just as you kind of had a preface, I think I will too. The president mentioned the time at the Attorney General's office when I was special prosecutor overseeing investigations resulting from when was a death caused by police conduct. And we did a number of those. And a significant recurring issue was serious mental illness. And it just presented over and over again. And as you said in your remarks, just the failings of the broader system, of the public health system, were on display when these tragedies were brought to us, the loss of a life, the use of lethal force by an officer. And then we were looking at it as a legal matter, looking at the self-defense law and looking at the facts and doing the forensics. But the inescapable big picture, as we connected the dots from investigation to investigation, was that so many of them started with a mental health call. And I know there's data in this space talking about the number of calls, the volume in police response. I don't want to go too far down that, but just for me, that is a significant piece in terms of my introduction to this subject in that way, just as you just talked about. And of course, the overlap when we're talking about gun violence is something that we're particularly focused on in the office. So with that, I will then turn specifically to your question, which is what our plans are, and noting what you talk about, that the notion of deterrence and putting out there that we're going to handle cases seriously, and the overlap with those who may be having a serious mental illness. What does that mean for that population that may not be doing kind of a risk reward calculus in the conduct? And so I wanted to kind of start with what's going on in the office now. As many of your viewers will know, Manhattan has a mental health court. And we now have about 50 active cases, 52 people in the court, and it provides the kind of, when you focus on serious mental illness, that's the focus of the court. And there's the ATI, the alternative incarceration part. There's the drug court, others that may be handling matters with people who have other types of mental health issues, but the mental health court is handling the SMI population. And I think it's important, as you said, to sort of really focus on that population. And we're talking about cases where alleged very serious conduct, but very, very significant supports. And as I've been meeting with the court, meeting with our assistant district attorneys to really see this from the inside, the level of support and scaffolding and care and treatment plans that go into this is exactly what we need to support and move forward and handle these matters. And so the great news is that it's happening as we speak, happening day by day. And then we're looking to scale that work up. I think it's extraordinarily important for the reasons you state. And there are a couple of areas that we're, kind of, I would say, specific points. I'm happy to get into them in more detail. One is, we look at the research that the efficacy of these programs is increased, made better, by the earlier the intervention. So we're looking at the delta between when a case is initiated and when it makes its way to mental health court, and trying to shorten that time period by embedding folks. We have a new division called Pathways to Public Safety that is, focusing on what traditionally may be called diversion or alternative to incarceration. And the thought is that we are going to embed those folks in our trial division, the folks who are responsible for the traditional prosecutions, and so that the earliest possible moment we can be looking at and then trying to get people into mental health court. That could be the difference of a year as we look at it. And so great work going on now and trying to just more quickly connect people to the resources of the court. And we know the research will improve. And we've got, I don't know what's visible to the viewers, but I see on one of my boxes, Shireen Crawford, who is heading up that division. And she's a veteran of CCI, the Manhattan DA's office prior to that, and is really helping us to imagine in many ways, but I would say most significantly that delta, that time period at the beginning of the case to connect. So that's what we're doing. I would be remiss if I didn't also state that I personally am a significant supporter of the concept of house, which I know the Greenburger Center is hard at work on. The notion that we would only have almost binary options, of a pretrial detention in the traditional sense, or sort of out and not having some sort of in between a residential area that could focus on these really significant mental health issues. So I commend that work, support it, and as we talk about what the next steps for my office are, having that sort of an option would greatly enhance our work. And so I'll leave it there. Happy to go into more detail on any of those. I'm very excited about the possibilities ahead in this space.
Thank you, DA, and thanks for the comment about Hope House. I think back to, I think it was 2015 when I went to see you in Albany when you were at the AG's office to talk with you about this, new type of residential alternative to incarceration for this population. And I thought then, oh, well, we would have this online in another year. And here we are. I do think that we are going to break ground in 2022, but it's taken too long. And maybe now with the focus that we all seem to have on the SMI population, we can move some of these alternatives forward. I hope.
Yeah. And I'm not an expert on the, Medicaid and some of the other intricacies. Yeah. But it strikes me that all of the voices in a chorus now talking about what have been some of what I understand, at least some of the obstacles may help kind of move some of those obstacles out of the way. It just would be just such an important option. If we look at the menu for the prosecutors in my office to connect people. It's just it would be, it's very, very important. So I want to lend my voice to that.
Thank you, DA. Just one other quick observation. You said at the outset that you were struck by the fact that so many of the people in police encounters, police, shootings, had mental illness, and from what I understand, the most at-risk person in a police encounter is a Black male with mental illness, and they're the most at risk. And so it's so important for everyone who cares about criminal justice reform, the Black Lives Matter movement as well, to focus in on this SMI population, because these are the people that are getting killed most often in a police encounter. So I appreciate you bringing that up. I wanted to circle now back to the people living with mental illness who do not pose an immediate threat or potential threat of serious physical violence, but who routinely circle in and out of the criminal justice system on lower level charges. We know that incarceration doesn't help this population either, and in the long run only serves to make them probably more ill and isolated, and it's extraordinarily expensive. So what are your plans for this population, and what resources do you think your office needs to divert more of this population away from the criminal justice system quickly and safely?
And so I really like the premise of the first question, sort of focusing on serious mental illness. This sort of brings in the second question, brings in other parts of our support apparatus, right? So we've got our felony alternatives to incarceration part, and we have our drug part, which obviously is focusing in the first instance on drug, but we know within that the overlap, which can present sometimes with mental illness issues. And so while we got the mental health court dealing with the issue you initially flagged, we have these two other courts, and like President Mason said, I've now been here for I guess about 45 days, and so I don't want to unduly take credit for what's already going on, but I do want to underscore it. So we've got the felony ATI part, great work is happening. And as you say, I've called it over the years sort of the churn, right? For the people who are going in and out and in and out and in and out. And those of us who've been in space know that, for some, the jail healthcare may be their first mental health care assessment. And so really trying to break that cycle and enhance the already existing work that's happening in our felony ATI part and our drug court. And it's the exact same model. And I'll mention Shireen Crawford again, because I think it's important. We're bringing, while there are 3 different courts in Manhattan, we're bringing it all to sort of one house internally, which I think is really important, to centralize it with someone that has the expertise that Shireen has, and so that we'll be able to sort of look holistically, see who's going to which court, making sure that that the assignments are appropriate, providing in-house expertise to our assistant district attorneys who are experts in doing the cases, but having the in-house expertise in which court someone goes to and the nature of diversion. But the hallmark will be the same. The number one thing we're looking at is time to connect to services. If someone is presenting with, whether it be serious mental illness or another type of mental illness, and then they go to Rikers for 9 months with that, treated in that context, but not connected to services and not acknowledged by sort of where they are in the court system, the situation is just getting worse. So structurally, and I don't want to sound too much like an org chart wonk, but I do think structure helps dictate policy. And so having us centralize these functions with someone who's can see all corners, so to speak, and at a senior level, an executive level of the organization, we're standing it up as its own division. I think we're going to see really significant gains in the already great work that's going on, because just by that one piece of shortening the time, taking something that can happen to take now 14 months, cutting that time dramatically so people are getting connected to services. That's our number one priority for both serious mental illness and then the other courts that I mentioned as well.
Thank you. Before we go on to the next question, do you have a sense about how many cases that your office handles involve people with mental illness, either serious or lower level mental illness?
So for serious mental illness, we have the data. We've got 52 people with 58 cases currently pending in Manhattan's mental health court. I do not think we have the data tracked across all of the courts in terms of mental illness that may not be categorized as serious mental illness. It's something as we're trying to centralize. It's one benefit, I think, of the centralization and all earlier intervention in cases. So I don't have the broader data. As you know, in some ways it is so broad as to be systemic, and so may prove very challenging to capture in all ways. But I do have it for serious mental illness. It's 52 people with 58 cases pending.
It's always struck me that the number of cases in mental health court are so small compared to the issue. I just know anecdotally that, the Greenburger Center also works upstate. And we just had conversations with our sheriff who said, well, the national average might be, I think it's 40% have mental illness in a jail. We're up to 60-70%. And when I was a bond agent for a nonprofit bail fund upstate, I would say easily 90% of the people that I bailed out had mental illness, a substance use disorder, or both. So, when I hear these numbers in New York City, that 58 people are in mental health court in Manhattan, there's got to be more people that are eligible. And, if there's ways that your office can help to increase that number, or whether that's an OCA issue where we need more capacity, I'd sure like to understand that better.
Yeah, so I'd love to talk about that for a little bit, because one of the great things about being new to a position, I guess we should always be asking questions all the time. But when you're new, you have even broader license to say, wait, what's this about? What's going on here? And so I've been doing a lot of that. And that question about capacity is something that we've been talking about. Right now, it's contractual, right? So OCA has a contract that provides for 50 clients, and so we're slightly over that number. But it's a conversation that we're having about, and I think just by virtue of cutting down the time period, even if you had the same sort of overall set of people, you have more just by virtue of folks in before others are have their cases resolved. So that's a conversation that we're having. And as is the case, I think, for a number of issues in this space, it's about resources and capacity. I think I don't want to speak for other system players, but I think it's if not unanimous, a broad consensus that that number, a contract of 50 could be replicated and expanded, several fold. Right. So that's a conversation we're having. What is I think needs to be underscored is it's a partnership, right? So it's the DA's office, so with the cases, it's the Office of Court Administration, it's the service providers. And so one thing is we're having our conversations about scaling up, which is extraordinarily important, and we can't scale up unilaterally, right? We have to do that in dialogue with the other stakeholders. And I would say, that includes talking about, what the capacity is, and which is obviously a current contract. So that would have to be altered, and then doing it also with the system providers and what their capacity is. And so doing it in a way that we want to move with dispatch, because this is obviously an urgent issue, but we also want to do it in a way that we're setting up everyone for success. And so there's a very, very kind of delicate balance there. And so we're having that conversation. I think there is broad consensus, if not unanimity, that the number could be several fold higher.
Yeah, right. Good. Well, good to hear. So some of these questions or concerns you've answered already, but I want to talk a little bit about the defense bar. In other conversations we've had with other DAs over the last a couple of months, the defense bar has raised concerns about certain features of mental health courts generally and specifically in Manhattan about the court's procedures and the offices, the DA's office's procedures, such as the requirement that defendants meet with DA staff and divulge personal information that could be traumatic or in some cases used against clients when they are not accepted into mental health court. So defense attorneys have called for clinicians, not assistant district attorneys, to evaluate mental health information and make decisions or at least recommendations about whether a defendant would be a good candidate for mental health court. And then to provide the treatment plans for the defendants to the defense counsel. So I'm wondering what plans your office has to address the reality that people with mental illness are in the wrong system. They're in a criminal justice system instead of a mental health system. And we need to make sure that mental health decisions are being made, or at least informed by clinicians and not lawyers or judges for that matter. So are you going to hire clinicians? Are you going to use more recommendations from outside providers? How do you address those concerns?
So I completely agree with the thesis that clinicians should go into clinical evaluations. We as lawyers have a lot of core competencies, but with the exception of, I guess, maybe a few, we're not doctors and not medical professionals, and so I completely agree that we need to be following the science in all ways. A bit of kind of historical context in Manhattan. I do think there was a time when there was more ADA and lawyer involvement in sort of driving the process, and the thought that the process, even with the clinicians, should be in-house. And so the office hired clinical staff and had it in-house to advise prosecutors on mental health issues. Now we work much more with outside service providers and are relying on those assessments. So for example, in it's EAC and mental health court, misdemeanors and CCI and felony matters, and we are looking at the process and part of a way to speed the process up and connect people to connect them more quickly to clinicians. Obviously, we have to do an evaluation of the case and be in touch with defense counsel, and there's lawyering to be done, but making the clinicians are the gatekeepers on the substantive medical issues. And you also mentioned proffers. I think that there's certain information, background information that may be relevant to the determination, but sort of things that are clinical questions should be asked by the clinician and not by the lawyers, and lawyers shouldn't be kind of driving that process. And so that's something that I think it's already was underway in Manhattan, but we're really looking to sharpen and drive. And I think the connection to the clinician is another way to improve the timing and cut some of the length of the time by having the lawyers get out of the way, while at the same time, obviously doing this legal work that has to be done on the front end, but not diving into medical work.
Thank you for that. I hope that in your conversations with Office of Court Administration, you have some ability to suggest to them or push them to replicate the Manhattan model, in more courts, mental health courts. The Brooklyn, did I say Brooklyn or Manhattan? Brooklyn model, around the state, because that model that Judge Demick has put together with clinicians in his office and with a staff rich in background in mental health diversion programs and helping to diagnose and recommend to the judge. I think that's equally as important to have the resources at your disposal, at the judge's disposal, and to, as you suggest, utilize the outside providers as a way to really get that information that, let's face it, judges and DAs, as you suggest, they're not doctors, this is kind of not what you signed up for, the police either, but it's where we're at. The reality is where we're at the moment, at least.
So I would just note on that, because I've looked, in particular, in Brooklyn, as some may know, our chief assistant in Manhattan is a recent alum from Brooklyn, was the chief of social justice in Brooklyn. Meg Reese is who I'm talking about. Also was with President Mason at John Jay, known to many here. And one significant difference in trying to replicate it is the funding stream. And so the conversation, as it often does, it goes back to resources. And this is a significant issue. And I don't presume to talk for anyone else other than the Manhattan DA's office. But my understanding is that the funding streams are quite different from borough to borough. And I think to the extent we're looking to replicate a chorus of voices on sort of where we should be put is quite helpful to help drive the discussion.
Thank you. So we have about 20 minutes left, and we have questions in the chat box, and Erica and others are sending me questions here on my phone. So I would like to try and ask some of those questions. And so I apologize for looking down. But the first question is, if someone with mental illness is sentenced to prison, how will your office follow up to ensure they are held somewhere they can receive treatment?
That's a great question. I'm talking about while in custody.
In prison, when they're sentenced, DA, when they're sentenced. I'm not sure that you have the ability to.
Yeah, so I think we have limited. I mean, we are having conversations with, another great part about being new is reaching out and introducing myself and talking about priorities, with others. And so those are conversations I'm deeply interested in and concerned about, both prison and jail conditions of prior life at the Attorney General's office, law, specifically about, medical treatments in one of the counties. So something of sort of great importance to me, but I also think, it's something about which I do not have, direct control. What I will say is upon release, and part of the thinking that we're doing on reentry, we talk a lot about job stability, and we talk a lot about housing stability, and we know those two supports correlate a lot with, actually I would say causation with recidivism, but also in this space too. We do have, and I think probably many here are familiar with the health justice network, which funded through some of the Manhattan DA forfeiture funds, organizations across north of Manhattan that are for people returning to a community from incarceration, and they are addressing both business and behavioral health issues. It's a voluntary program, and so it's not while folks are in custody, but I think that's an important resource that we're going to be letting people who are returning about. And again, something else that trying to scale up, and I hate to sound like a record owner, but it's also something which I believe the funding is soon to lapse. And so it's an important post-incarceration support to help people for physical, but here relevant to this conversation, behavioral health issues. So I just wanted to mention that, even though it's not directly about the period of incarceration and healthcare then.
Yeah, this, as far as I know, once they call it the body is transferred to, state prison, you kind of as a DA and judge lose a lot of the ability to control any of that. But a follow-up question to that is, if there are people currently held in DOCS facilities, I think they say DOCCS, so I guess that's, I don't know if they mean state or city, that's state, right?
I think they're referring to, and I can see the chat logs that comes. I think they're talking about DOCS in terms of state direction and oversight for state prison terms is what I think. Obviously, the city commissioner, who I had a chance to meet with briefly, has oversight of Rikers for jail. So I got DOCS in the city, and I think it's a difference of a C. So it's like
a difference of a C. Right. Yeah. Thanks, Sean. I just see Sean from Vera. Thanks, Sean. I thought so too, but I thought, well, maybe anyway. It's a similar question. Okay, so the rest of that question, about would you consider resentencing?
So this is, and here I'm going to actually see if I can open the Q&A so I can actually see all the things you're seeing too. Got it. I see the question. If there are people. So, right now we've got sort of, if I'm understanding the question correctly, we've got a conviction and a sentence that we have limited, kind of procedural options in terms of resentencing. There's certainly a bill. I don't know exactly what stage it is that would allow for clawbacks and allow you to sort of, in the interest of justice, revisit a sentence. And I certainly support that. I know, I believe Professor Foreman at Yale has written about it, and I know there's a New York bill. I don't know if it's been reintroduced this session, but I do think giving prosecutors the ability to, outside of the sort of, habeas context, to look back at sentences and make adjustments in the interest of justice is something that is important. I'm just not so sure if the bill was reintroduced this session or not.
Okay. Okay, so another question we have here is what progress, if any, has been made in police departments to partner with mental health professionals to respond to mental health crisis?
I'm sorry, I got distracted because we're getting such great support from the chat log. I believe our colleague from Vera says that the bill has not yet been reintroduced.
Got it.
So I apologize. I was reading and not listening, so I missed the last question.
That's okay. We have to multitask more, I guess, here, but yeah, I'm reading it too now. Yeah. Well, thanks again, Sean. So, okay. So the question, just to repeat, was what progress, if any, has been made in police departments to partner with mental health professionals to respond to mental health crisis?
So, saying is starting first with sort of kind of on the national level. I think people are, familiar with the CAHOOTS program in Oregon. We've had a couple of others. I wouldn't call them pilots. I think they're actually, the policy. So we have some models, and I know we had a pilot in Manhattan in East Harlem, and so it's something that is being examined here. I think operationally it may be more difficult given the density and sort of also the size of the city, but certainly given my experiences, handling those investigations at the Attorney General's office, in the responses, it's something that I support, having kind of mental health professionals, certainly be part of the response, if not exclusively the responders in certain instances. I think is something that's really, really crucial, and I'm encouraged by what I see in other parts of the country and the fact that we're starting to pilot it in New York City as well. I think it's a matter of getting it to scale here.
Mm-hmm. Yeah. Another question here is what are the eligibility requirements for mental health court? Are violent offenses eligible? So
the short answer is yes. I mean, the in terms of our violent offenses, violent allegations, charges eligible. The going back to I think your very, very first question, in order to be eligible, there has to be a diagnosis of serious or severe mental illness, and we are talking about that population and not broader mental health issues. The majority of the participants is also suffer from substance use disorders. But the diagnosis of an SMI is the sort of the number one. You have to be 18 years of age. The serious mental illness must have had a significant impact on the kind of everyday functioning and must have contributed to the conduct that resulted in the arrest. This may be obvious, but I should say that the participation is voluntary. And so I think that those are the sort of main features. But in terms of the charge conduct, yes, it runs the gamut. And as I say, as I've been looking at the current docket, it does kind of run the gamut in terms of the types of conduct charged.
Okay. Another question is, does your office require PPI, a PPI to prove mental illness in order to receive diversion? I think they mean pre-sentencing or maybe pre. I thought it was maybe pre-probation or probation, not pre-probation, but probation. report, but I'm not sure. Who can tell me? Pre-pleading, yeah, pre-pleading information. Thanks, Aisha.
So we're in the process of sort of looking at the whole, we're in the process of looking at the process in terms of what features we think are necessary for us to make, get the information we need to make a recommendation to the court, which I know is important that the court have faith in what we are recommending. But we're taking a look at, I mean, one of your initial questions was about, the proffer system and what is a proffer in terms of information that may be asked that may have a chilling effect. So we are looking to streamline the process in a number of ways so we can perform our lawyering function, but really get out of the way, if you will, for the clinicians. And so I think that's something that we'll be assessing. I think the more information, particularly from that we can get to the clinicians, the better. But in terms of the specific answer, I don't know, and particularly not so sure exactly what the PPI is standing for there.
Yeah, the pre-plea investigation. So I know upstate we get an investigation report from the probation office, before the judge sentences. So I think that's what, yeah.
Got it. Yeah, so we're assessing the whole system, and again in connection with the court. So our whole view is to sort of be able to streamline so we can get people into mental health court quicker. So in terms of sort of our screen, we're going to be really streamlining to get people into mental health court. Now, then, of course, what the court requires is a separate matter.
Okay. Another question is, understanding that you are new to your role and still figuring out all the programs and services that are available, are there particular gaps in services and programs that might make you more comfortable diverting people with mental illness?
I got caught reading. I was reading Liz Gazen's more that we should choose not to oppose 440, which was going back to the prior one, and that certainly is an option, sort of one that I mentioned, sort of having the clawback in the bill, and something we'll consider. But I do think having the bill in that space would be really, one we can be probably more, I don't want to say intellectually honest, I don't know if that a phrase is exactly apt, but something in that space to really articulate the reason for the clawback, and would be really kind of undergirded, I think, by a change in the law. All right, what was your last question? I'm sorry.
Yeah, sure.
I'm going to close the chat log is so engaging. I'm going to close it. I'm just making sure I'm giving you my full attention.
I know, it's one of the reasons why I have Erica or other people send me the questions, because I get, I read it as well. So, okay, understanding that you are new to your role and still figuring out all the programs and services that are available, are there particular gaps in services and programs that might make you more comfortable diverting people with mental illness?
So this is something that we are doing, again, led by Shireen, doing a kind of an assessment of what to recommend for what types of services, and really have not focused on sort of gaps, although I do think as a general matter, particularly sort of broadly talking about ATI, there are gaps in terms of ATI for charged violent conduct. But really what we've been probing is also just efficacy. So making sure that even if a program is accepting someone, really be measuring, the level and nature of services provided over time. That's another key focus. Certainly we'll be looking to see if there are delivery gaps, but right now really just looking at kind of efficacy.
Okay. So I'm also getting questions from others that are not on the chat. And one of them is, do you support, for this goes to bail reform. So do you support having a judge impose additional requirements as a condition of getting out and not posting bail? So the judge would say, I'm going to either post bail or not post bail, but you need to do X, Y, and Z. You need to go and go to treatment while you're out.
Yeah, so putting those two together is sort of interesting. The law obviously requires it's least restrictive, and so going to be instances where least restrictive is just going to be the programming, and that's something where we're working with our partners to deliver on. I do think, something that is I think done less. For folks who know from the introduction, I was I was a federal prosecutor for years, and something that is done less in the state system than the federal system is to have a package that is having more than one, instead of sort of not just a menu of, okay, here's bail over here or supervised release with the following conditions. And so that's something I've been asking about. I think this is a practice that differs from county to county in state court. But yeah, having a package that is meeting people's needs and is the least restrictive is something that I'm very interested in. But I wouldn't say just kind of layering on to layer on, making sure that it's the least restrictive that's going to get someone returned to court, while many times that's going to be providing the service, right? And having the service that is addressing the underlying issue, not just for the return to court, which is obviously the bail question, but also the underlying charge, which is the ultimate question to society.
Mm-hmm. So this question is not necessarily about SMI, but I'm going to direct your attention to it anyway. And it's about whether you would change the practice of an automatic letter sent to the parole board asking the board to deny folks parole on the sole basis of their crime committed.
Yes, we're doing a couple of things. We're changing that default practice, and we're also centralizing it. Again, not to sound kind of like an org chart wonk, but having it centralized and having it connected to folks who are thinking all the time about these issues of reentry and diversion. I think it's an important place for it to live, and changing the default for the default that is that reversing the input such that it's the default of police. And then obviously, with an examination of all the facts. So yes.
Okay. You kind of answered lots of different parts of this question, but if I'll just direct your attention again to the question by Jeffrey Berman about whether you'll push for expanding the number of participants allowed in the mental health court.
Yeah, I think we need more capacity. I think we've got to do it in a way that allows us to scale up as we are, scaling up with our service providers. It's a contractual matter, and it's a contractual matter of OCA, so I don't want to sort of overstep and suggest it's something I could alter. But I do think there's a broad consensus that there's need, and there's more need greater than 50. And I think as we do efforts internally at the district attorney's office to focus up and scale up, we will drive that need, and the numbers will reflect the greater need. But we've got to do it in partnership with the service providers and the court. Otherwise, obviously it's not going to work.
Okay, DA, I have to bring your attention and the audience's attention to a comment by Audrey Hall. And she says, DA Bragg, I am the mother of Christian Hall, whose picture has been in the news next to yours in an attempt to discredit you. I am so sorry for that, but my son is mentally ill, and we have tried for years to get him meaningful help. DA, would you like to respond to that?
I guess I'll respond by saying I appreciate the comment and the outreach, given that I think this pieces of this that are outstanding. I'm happy to maybe connect offline, and we've got resources in the office that may be helpful. But I don't want to respond publicly to a matter that's sort of ongoing.
Fair enough. I think Ms. Hall's comment is so representative of parents I have heard from across the country who are so desperate to get their children into mental health care when they see them going down this road to the criminal justice system, and they simply can't for so many reasons. Appreciate you can't comment, but I will just say you are not alone, sadly, Ms. Hall, and I hope that, we can address these concerns in a future forum, but more importantly, I hope our federal legislators and state legislators will finally change Medicaid rules and the other obstacles that are frustrating the development of residential and supportive housing for this population, because in the end, that's what they need. And they get it one way or the other. They just get it in prisons and jails if they can't get it the right way.
Yeah, and I would just add, and I think this audience understands the constraints, but obviously that does not take away the human dimension here, which I can sort of hear the tone even through that. And so I understand and look forward to connecting in an appropriate way offline.
Yeah, fair enough. Okay, we have 3 minutes. So I'm going to ask a very quick question here. I don't really know what FWC unit is, but do you?
I do not know. There's so
Okay.
many acronyms.
I don't either. I thought you would know. 30-second update from Sean. Sean, you're killing me here. Can you tell us what FWC is really quickly? Okay.
Sean has been active in the chat. I'm sure he'll be back. We've got to have Sean be attentive.
Oh, there he is.
Free the wrongfully convicted. Oh, okay. I was thinking mental health. Yeah, we are. We've actually also changed the name of the unit, which is the reason why the acronym didn't jump off the page to me. So we have someone running the unit now, Terry Rosenblatt, who some of you may know, starting, and we're taking a look at the docket and also figuring out how to most appropriately kind of give it the staff and resources it needs. And then something I'm spending a fair amount of time doing these days is figuring out how to get resources to priority areas, and also obviously do the core. Well, I don't want to say it's all the core work of the office, but yeah, the unit has I think has new leadership, and we're looking forward to really kind of diving into specific matters, and that process is underway.
Thank you, DA. We have 1 minute. Would you like to say anything in closing?
Just I really appreciate the opportunity to have opportunity to be in dialogue with you about these really important issues, and as I think the last 15 minutes have also to be in dialogue with this great community. The active, informed comments and questions, and just look forward to partnering. Just underscore that we need the partnership, right? Just as I talked about how we scale up mental health to the courts, and the service providers. Almost everything we do, we need to do in partnership, and I look forward to partnering with so many of the kind of not just thought leaders on here today, but action leaders and those who are providing key services. And so as we go forward to the further into the year, and we're going to keep forward driving our priorities. Look forward to doing that in partnership with you and informed by you as well. So thank you so much.
Thank you, DA, very much. Thank you all for tuning in and for your terrific questions. And we'll see you again in March. Thank you, DA.
Thank you.
Good afternoon.